Welcome everyone to this Free State Foundation event, a virtual event, which I've titled The Supreme Court, the FCC, and Communications Law. I'm Randy May, president of the Free State Foundation. Our featured speaker today is the Cato Institute's Ilya Shapiro, and we're delighted to also have Christopher Yu and Seth Cooper as participants in the program today. I'm going to give them proper, or at least semi-proper, introductions in just a moment. But first, taking care not to steal any of the speakers' lightning or thunder, I'll just say briefly that we're going to be discussing the Supreme Court's current and prospective cases that in one way or another may impact communications law and FCC decisions. There may well be other areas and topics covered, but I anticipate that Ilya and the commenters will touch on the NonDelegation Doctrine, Chevron deference, the status of independent regulatory agencies, like the FCC, and other administrative law topics as they may impact, for example, net neutrality, speech regulation, the First Amendment, and so forth. Now I'm going to introduce our truly distinguished group of speakers. I'm only going to give you some of the highlights of their bios. That's what I meant earlier when I said semi-proper introductions. You can find all of their schooling, honors, publications, and so forth on their respective websites. So first up today will be Ilya Shapiro. Ilya is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of Cato's Supreme Court Review. Before joining Cato, he was special assistant advisor to the multinational force in Iraq on rule of law issues and practiced law at Patton Boggs and Cleary Gottlieb. Ilya is the author of the recently published and widely acclaimed book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court. He had the good fortune to have this book come out shortly before, I think it was just a week or so before perhaps, the president's nomination of Amy Coney Barrett. So that timing was good. Here's the book. I think you may see a couple copies on Ilya's bookshelf too when he speaks, but this is my own copy. You can see I've got quite a few Post-its here throughout the book. I can vouch for.
I hope that's not the errors that you're going to point out to me.
No, they would be in red had I found any, but those are points particularly that I wanted to be able to go back to easily. So obviously I've read the book, as you can see, and I can vouch for the fact that not only is it timely, interesting, and informative, but it's also entertaining as well. And I think when Ilya speaks, you'll probably see he's got a quick wit. I don't want to put him on the spot to entice him to display too much of that today, but I've seen it many, many times. Supreme Disorder is really a superb recounting of every Supreme Court nomination since the founding, right up to the present son's Amy Coney Barrett. And there's a lot of rich material to consider, especially regarding the modern day nomination fights, beginning with Robert Bork and on through Brett Kavanaugh's. Ilya's the co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution. He's edited 11 volumes of the Cato Supreme Court Review. He publishes in a number of publications, and I'm going to let you go to the website to get all of those. They're numerous. I just mentioned that he's filed over 400 amicus curiae, friends of the court briefs in the Supreme Court. That keeps you pretty busy.
Have a good team.
Here,
I didn't say that I wrote 400.
That's an awful lot, and I know from observing that you have a high percentage of being on the winning side in those groups and having the court pay attention to those. One thing I'm going to mention, because I'll come back to this later, is that Ilya, you were a Lincoln Fellow. That caught my eye at the Claremont Institute, because I know a lot of your fellow Lincoln Fellows as well. Okay, and now I'm delighted that Christopher Yu is back with us. Christopher has participated in probably as many Free State Foundation programs as any other participant that's not a Free State Foundation staff person, or at least he's near the top of that list, and I'm grateful for that. Christopher is the John H. Chestnut Professor of Law, Communication, and Computer and Information Science, and Director of the Center for Technology, Innovation, and Competition at Penn Law School. That's a mouthful of a title, Christopher, but I hope I got it all out correctly. I'll just say that Professor Hughes is one of the nation's leading authorities on law and technology. He's one of the most cited scholars in administrative law and regulatory law, as well as intellectual property. His research interests are really varied. You can his website, but there's a basket full of those interests in which he has become really a prolific and leading scholar. And then finally, today, Seth Cooper is with us. As most of you know that have joined us, Seth is Director of Policy Studies and Senior Fellow here at the Free State Foundation. Seth is authored of numerous articles as well. His work's been published in the Washington Examiner, Washington Times, San Jose Mercury News, the Washington Examiner, and so forth. And then finally, the other thing I'll say about Seth is that he is also, or has been, a Lincoln Fellow at the Claremont Institute. Ilya, Seth was in the 2009 class. I'm not sure which class you were in, but I know by virtue of the fact that you and Seth were in that program, and many others that I know as well, that it's one thing among others. It gives you a terrific grounding and important fundamental foundational constitutional principles. So with that, this is what we're going to do, folks. I've asked Ilya to speak for, roughly 15 minutes to start us off. And then after that, Christopher and Seth are going to give comments for 5 or 6 minutes, reactions, and then we'll hopefully have some further reaction among us. And depending on the time, I may ask for questions from the audience, which you can put in the chat function. So with that, Ilya, take it away, please.
Well, thanks very much, Randy, for the introduction and for inviting me to speak here, to have this event, to promote my book, and otherwise. I've learned so much from you and the Free State Foundation over the years. Particularly, I'm a generalist. I'm kind of an appellate constitutional Supreme Court generalist, and always the intersection of intellectual property, communications, administrative law, and the Constitution is a great place to be, and that's the great niche that the Free State Foundation occupies. For all of you who are watching, whether live or later on recording, if you buy my book, we can't do in-person signings these days, but I'm happy to mail you a signed book plate. You send me your address, I'm happy to send that to you. And if you go to Supreme Disorder, there you go. If you go to supremedisorder.com, not only can you find different places to buy the book. If you don't like Amazon, you can go to Barnes & Noble or your local independent bookseller. But for free, you can download a 20-page statistical historical appendix, so you can really nerd out on this stuff and be very popular at your next Zoom cocktail party. But there is a key intersection between my book, which tells the story of the role that politics has played in judicial nominations, how we've gotten to the kind of toxic moment where every time there's a vacancy, we go to DEFCON 12, and it's one of the hugest set pieces of public discourse that we have, and administrative law, including telecom. And that's the thing that the issue is that the senatorial brinksmanship, the high stakes that we've seen, it's symptomatic of a larger problem that began long before Brett Kavanaugh or Merrick Garland, Clarence Thomas, even Robert Bork. And that's the court's self-corruption, aiding and abetting the expansion of federal power, and then shifting that power away from the people's legislative representatives and toward executive branch administrative agencies and so-called independent agencies, for that matter. The judiciary affects public policy more than it ever did, and those decisions increasingly turn on the party of the president who nominated the judge or justice. So as the courts play more of a role in the political process, of course, the judicial nomination and confirmation processes are going to be more fraught with partisan considerations. This wasn't as much of a problem when partisanship meant rewarding your cronies, but it's a modern phenomenon for our parties to be both ideologically sorted and polarized, and thus for judges nominated by presidents from different parties to have such markedly different interpretive theories or constitutional visions. And we can see that with Donald Trump's appointees. Former White House counsel Don McGahn, who I've spoken with repeatedly, I've known him for a long time, going back to when I was at Patton Boggs, he told me, and this is quoted in my book, if you get the administrative stuff right, everything else will fall into place. And of course, Don was the architect of President Trump's much vaunted judicial nomination strategy. For example, Neil Gorsuch, right, his first of 3 Supreme Court nominees. Those who hoped for or feared a smooth writing originalist got what they expected. And Gorsuch has continued his campaign against the awesome power of the administrative state, both regarding judicial over-deference to agencies and congressional over-delegation of legislative power to the agencies. In the 2018-2019 term, for example, in which Gorsuch was in the majority of more 5-4 cases than anyone else, 2 such cases where he was in dissent illustrate his commitment to the separation of powers. Gundy versus United States, Gorsuch there led the opposition to a ruling that okayed the congressional delegation of power to write sex offender registry rules, criticizing a statute that, quote, gave the attorney general free rein to write the rules for virtually the entire existing sex offender population in this country. And I'll go back to that case. In Kaiser versus Wilkie, he decried the refusal to erase the deference that courts give to regulatory reinterpretations. That is, Chevron is deference to agency interpretations of their governing statutes. Kaiser was treating so-called our deference, deference to agency reinterpretation of their own previous regulatory decisions. And Gorsuch wrote that the majority's rewrite, quote, has maimed and enfeebled, in truth, zombified our deference, keeping it on life support, but depriving lower courts of clarity and litigants of the judicial independence that the Constitution guarantees. In this pen and phone and tweet era, I think it's refreshing to see a jurist recognize the lack of accountability in a system driven by bureaucrats rather than legislators. And this is a nonpartisan complaint. Agencies are run by administrations of both parties and can promulgate rules that achieve both conservative and progressive results. It's unclear why Democrats wanted Trump's cabinet secretaries to have more power, but that's what they were implying in their attacks on Gorsuch for wanting to cut back agency discretion. Gorsuch's work is not what you'd get from a judicial restraint conservative, and signals the sway that he'll have in coming years over the debate on the proper scope and distribution of federal power. And then there's Brett Kavanaugh, whose willingness to push back on the excesses of the regulatory state also make him a man for the moment. Yet he approaches his task from a different angle than Gorsuch, where Gorsuch wants to pare back the scope of judicial deference, Kavanaugh has focused on reducing the occasions where deference is applied in the first place. For example, under Chevron, where again judges defer to agencies when the operational statute is ambiguous, Kavanaugh would rather judges work not to find, let alone manufacture, that ambiguity. So it's kind of an approach that Scalia had at the tail end of his career. Earlier on, Scalia was much more deferential. Later on, he had that kind of what I just described Kavanaugh as attacking. Don't give the agencies that many opportunities, because do the hard work of interpreting the statute. And I think Amy Coney Barrett, who certainly did not have as many administrative law, hardly any opinions, and that wasn't her focus in academic writings, as Brett Kavanaugh, who's on the DC circuit, and Gorsuch, who had a real interest in this area. But I think to the extent that she's, as she said, she's very much like her mentor, the late Justice Scalia, I think she'll go along with that. So what does that mean for Chevron, or for that matter, deference? Well, that Kaiser case that I mentioned narrowed the standards by which, or the occasions when, courts are to defer to agency reinterpretations of their own regulations. Elena Kagan, Justice Kagan, wrote the majority opinion and basically rewrote our deference. I mean, that level of deference should now be called Kaiser deference, because in effect, the majority did overturn or at least rewrite it to such an extent that it's now a different doctrine. And in fact, both John Roberts, the chief, who concurred with the majority, and Kavanaugh, who dissented, joined Gorsuch's lead dissent. They both wrote separately to say that there's really not much difference between the Kagan majority, which purportedly upheld deference, and the Gorsuch dissent, which would have overturned it. And I'll note just here that Justice Kagan, her seminal academic contribution is her law review article, now 20 years old, Presidential Administration, in which she spends over 140 pages defending President Clinton's leveraging of regulatory agencies to pursue his agenda. As we have a very closely divided Congress with President Biden, I think more executive actions, not kind of the symbolic ones of rejoining the Paris Accords and certain other things that we saw this week, but once we get more deeper into regulatory action, there's going to be that renewed debate, and that Kagan versus Gorsuch, or Roberts versus Kavanaugh, for that matter, we're going to see that dynamic. And this is where I think Randy's article, Randy doesn't publish that much, relatively speaking, but when he does, these things are relevant, and they continue to be useful and cited many years in the future. So like Kagan, Randy May published an important law review article in 2001 about the public interest doctrine as it relates to communications regulation, and whether that's unconstitutional based on the non-delegation doctrine. We're going to see that debate now. And for that matter, Randy's 2006 article about giving independent agencies less deference than even what is given to executive agencies, because they have less political accountability. And you have to, ultimately, our separation of powers doctrines is about political accountability. Now, with respect to this non-delegation issue, which I think is going to come up, will come up for serious discussion, because the Supreme Court took up the case of FCC versus Prometheus, which has been going back and forth in the courts for over a decade, very long time, after many remands between the FCC and the Third Circuit. And here, the FCC has really been trying to get rid of the 1975 ownership concentration limitations in light of a 1996 congressional directive to review whether those limitations remain in the public interest. And this is on top of antitrust law. There's still, the FTC or the DOJ can review whether there's ownership concentration or monopolies in that respect, but this is above and beyond that. Well, is this too much delegation of legislative authority to the FCC? And here's where that Gundy case that I mentioned a couple of years ago, Gundy ended up 5-3. This was when before it was argued the week before Kavanaugh was confirmed. So an 8-justice court And no federal law has been struck down under the idea that Congress delegated too much legislative power to the executive since 1935. But here there's a real chance, kind of open-ended delegation. When Congress passed SORNA, the Sex Offender Registry Act, it was a huge legislative compromise, but they could not agree on how to treat sex offenders that were already in the system before this new federal law was passed. And so basically they said, okay, Attorney General, you write the rules for this, period. Not really an intelligible principle or anything else, as Gorsuch ended up pointing out. But anyway, the four Democratic appointed justices said this was not a non-delegation problem. There were some who thought that maybe Justice Sotomayor would say, at least in the criminal realm, too much of a grant of power to the executive was not good, but she ended up folding into the main Kagan view on this. Justice Alito ended up concurring in the judgment, not in their rationale, because he found it to be an unusual case, but said that in a more typical or kind of run-of-the-mill challenge, maybe a telecom challenge, who knows, he might be willing to consider it. And then Gorsuch, joined by Roberts, without Roberts writing separately, and Thomas said, yes, it's non-delegation. We need to revisit that doctrine. And then later, in a case that Kavanaugh was participating on the shadow docket, one that wasn't fully argued, but a summary decision, Kavanaugh also indicated that he was willing to reconsider it. Presumably Barrett is there as well. So there's at least 5 votes. I think non-delegation is an active doctrine, and again, couldn't come up in this FCC versus Prometheus case. And this issue of deference to independent agencies possibly being different than deference to executive agencies, Randy's idea, that could come up as well, because there's been a lot of litigation, many cases before the Supreme Court, including this term, about federal presidential control, ability to remove and appoint, the appointments clause, as we've seen an active issue with President Biden's this week firing the general counsel of the NLRB, the head of the CFTC, the CFPB, all this alphabet soup of agencies, of course. So anyway, part of that will go into deference doctrines. And Brand X, the deference the courts show to reasonable agency reinterpretation of statutes, even when those new interpretations conflict with prior court precedent. So it's agencies, in effect, overruling or creating new law that supersedes court decisions. Justice Thomas, who wrote Brand X, has now expressed a willingness to revisit it. At the time, Justice Scalia dissented from it. And I think we're going to see a Brand X revisitation as well. Gorsuch had written about that in the lower courts too. But anyway, we've gotten to where we are in terms of this whole judicial debates and kind of the business about appointments and all of these, what otherwise are dry issues, being elevated to part of our political discourse or mistrust, because Congress and the presidency have gradually taken more power for themselves, and the Supreme Court has allowed them to get away with it, aggrandizing itself in the process. As the court has let both the legislative and executive branches swell beyond their constitutionally authorized powers, so have the laws and regulations it now interprets. Competing theories battle for control of both the U.S. Code and the Federal Register. So, of course, judicial confirmations are going to be fraught, particularly as I noted, different interpretive theories map onto political parties that are more ideologically sorted than ever. And there are 2 big buckets of cases where that dynamic has contributed to the ratcheting up of tensions that has both crumpled Senate norms and filtered down into lower court nominations. First are the cultural issues, of course, and that's way beyond the scope of this panel. But second is what I call size of government issues, which encompass everything from environmental regulations to Obamacare, guidance documents to enforcement practices. As the response of the conservative legal movement to various judicial provocations has shifted, the debate over the court's posture has crystallized. From calls for restraint in the face of the Warren courts making up social policy out of whole cloth, which ultimately led to too much deference to the political branches, the focus now is on engaging with the law. That approach often calls for invalidating laws rather than exercising what noted Yale law professor called exercising the passive virtues. Indeed, activism has become a vacuous term that conveys nothing more than disagreement with the judge or opinion being criticized. The battle has been joined over the legal theory rather than judicial process. That is, so long as we accept that judicial review is constitutional and appropriate in the first place, and how a judiciary is supposed to ensure that the government secures and protects our liberty without it is beyond me, then we should be concerned only that a court gets it right, regardless of whether that correct interpretation leads to a challenged law or regulation being upheld or overturned. To paraphrase Neil Gorsuch at his confirmation hearings, the little guy should win when he's in the right, and the big corporation should win when it's in the right. The dividing line then is not between judicial activism and restraint, but between legitimate and vigorous judicial engagement and illegitimate judicial imperialism or abdication. And it's a generational battle. Do you get into the fight over federalism and the separation of powers, or do you sit back and let the political branches handle that sort of thing, preferring not to mess up your judicial robes? And that gets us back to the debate over the administrative state regarding deference doctrines, congressional delegation of legislative power, and even more arcane areas of regulatory law, which is why judicial selection is so consequential. I'll leave it there, and I look forward to Chris and Seth's comments and to all of your questions. Thanks again for having me, Randy.
Thank you, Ilya. That was terrific. I know it called several questions to mind that I have, but rather than jump in now, I'm going to call on Christopher Yu to speak next. And I'll just say, I know when I introduced Professor Yu, I said that he has been one of our most frequent guests outside of FSF staff at our conferences and seminars and so forth. And yeah, but I don't think I said that he first spoke at an event back in 2005, I think, when I asked him to speak on net neutrality. Christopher then was down at Vanderbilt Law School. And today, I wouldn't be at all shocked if he mentions net neutrality. So, you know, that's just verification of how long we've been dealing with this issue back and forth, which I think does ultimately raise interesting, important, fundamental ad law issues. So, Christopher, it's great to have you back, and go ahead and take it away, please.
Well, Randy, thank you very much. I appreciate being here. It's an honor to be speaking at Free State Foundation event again. It's funny you mentioned net neutrality. I actually consider it a good talk when I can avoid. I always take it postponing discussions going into network neutrality as long as possible as a good sign. I've been predicting the end of that debate since about 2010. I've been wrong, and let's just say one thing about the current political situation, it's guaranteed to come back. And so that's an aspect of Chevron and the way that we've set up administrative law that is now part of Chevron deference, which means whatever a new administration wants to do, they can do. And so I think it's a wonderful capsule or a lens through which we can frame our discussions today. So I'm going to actually I may do something, I'd like to spend my short time doing something that may surprise some of you, which is, you know, Ilya's remarks have been very helpful. And actually, this is the first time we've had a chance to meet. Just one note, Ilya, I actually go by Christopher instead of Chris because my wife is named Chris. And so one of the things is your remarks are about the court and formal legal action and very much in what I think of as a formalist perspective. And I say this as a formalist myself. You know, if you look at my writing endorsing the unitary executive, it's very, very much in that tradition. And I very much am a sympathetic person to that. But to back up from a little bit and to take a more historical, actual, sort of, if you will, more positive perspective, the Chevron we talk about is really a product of the 1980s. Really a turn reflected in Boucher versus Sinar and INS versus Chadha towards really looking at lines of political authority. And Chevron, there's been a long-standing idea of deference to agencies, and that goes way back a century or more, but is really tied to presidential accountability and invokes what I think of as sort of the legal process school's emphasis on taking policy-oriented questions and giving them to politically accountable branches. And it's backed by the realist understanding that statutory interpretation is in fact policymaking. If you look at the origins of many of these fights, though, about independent agencies and the non-delegation doctrine, they really have their roots in the New Deal and the progressive movement and the work in the writings of James Landis. Now, that motivation was not really about political control. That was about technocracy and a belief in scientific management and the idea that we could actually improve administrative decision-making by getting, I remember from, if you look at the Brownlow Commission's reports, like people, administrators with a passion for anonymity, people who just wanted to get it right. And they had a huge faith that that would work wonders in terms of improving decision-making. It leads to independent agencies, it leads to multi-member agencies, it leads to insulation from removal, and it leads to a broadened non-delegation doctrine. And under the Landis vision, you wanted to insulate all of administrative decision-making from politics. But in addition, they wanted to insulate it from law. They thought that those were things that caused problems. And so what's interesting is when we think about how these doctrines have evolved, we can actually look at it through two lenses. And what I'd like to think about right now is a modern assessment from our current stage. How does the formalist political lines of political accountability work? How do we feel about that now? Particularly as we're changing over administrations, we're seeing how the last administration ran its affairs and how a change of administration with different political leadership is going to change things and what that means. And how do we feel about expertise? And I'll talk with the expertise first more briefly. As you know, there's been a huge critique of this through capture theory, really led to the enactment of the APA, the Administrative Procedure Act of 46 by itself, but more importantly into the advent of hard look review on top of what was supposed to be a minimalist APA. And you see, but the funny thing is, I would say we've seen a discrediting of expertise. We are starting to see political science. We're starting to see agencies as captured. We're seeing Niskanen thinking about them as empire building. We see Mansur Olson understanding that in administrative processes, different types of people get different levels of representation. And we have a growing skepticism of the expertise theory. What I would like to posit, though, is in the last 4 years, what the new administration we see is an embrace of science. And what we saw in the last administration, what is often criticized for rejecting science. And channeling, if you will, my inner Ayn Rand, if you will, there is, even in a world where administrative decision-making is often heavily a policy matter, there is a core of it which might be properly regarded as technocratic. And in fact, one of the interesting questions to me is, if you'd asked me to have this conversation 10 years ago, I would have been very skeptical about that core. I would say the experience of the last 4 years has made me much more amenable to it, to the idea, when you look at COVID response and other things, that there is possibly something to be gained by that. And there's a greater credibility for me that now than there was not that long ago. When we think about political control, we think about having accountable agencies, agencies that are politically accountable, making decisions instead of judges. And what is interesting is, if you look at the scholarship, there's an interesting question. If you think about it theoretically and formally, we should just think of the executive branch as being more accountable. It's not clear how true that is. But when we move to multi-member agencies, what we see are votes among different people. It's often vulnerable to personal politics. We all know that it's very rare for a chairman to lose a vote. But on the rare occasions you do, it's often because one of them breaks, and it has to do less with grander political control aspects and more the personal politics of multi-member agencies. In fact, there's a great deal of scholarship questioning how independent agencies are. A good example is when Kevin Martin's wife was on the staff of Dick Cheney as vice president, that in fact and if you read, as you mentioned, Elena Kagan's famous article on presidential control, you see directives coming from the White House even to setting policy to independent agencies. And the great example to me is network neutrality. He issued at the YouTube video saying he wanted to shift the title to a different form of legal approach. Tom Wheeler insisted he was an independent agency. He resisted it quite a bit and seemed to be giving all signs that that's not the direction he wanted to go. but having had that speech out there, eventually found the political pressure overwhelming. And so what you see is, in terms of even an independent agency isn't invulnerable to the bully pulpit of the presidency. And so you see a much more complex set of dynamics. And what you see coming out of the modern political science scholarship and legal scholarship is a greater sophistication than what I think of the simplistic legal process movement, which is we used to just choose a branch, a single branch, and say they're more accountable than courts, and therefore we should leave decision-making to that branch. In the legal process school, it was legislatures. If there's tough cases, and we see this in deference on the substantive due process, let the legislature decide and don't have the courts come involved. And we see this in administrative decision-making showing up in this notion of Chevron. And I think what was evolving is an awareness that none of these so-called political branches are perfect representations of actual democratic ideals. And that's by design. So for example, the Senate is not designed, and the whole notion of representation of Congress is to get individual regional decision-making, whereas the president reflects a diffuse national majority. And the belief is that some fusion of smaller group representation and national representation yields to better decision-making. And then we have embodied in the Great Compromise in the Senate an idea that states get equal representation versus individual representation. And we have all these different dynamics at play, even among those two branches. And then we have agencies, which we now understand are subject to political control, but not entirely perfectly so. And then they have different constructions and different internal workings that actually lead to different results. And that from a certain point of view, even judges are not immune to political control or political influence. From a longer term basis, they are appointed by political actors. So as they evolve, they come over time. And there is some extent to which, that they are aware of the institutional role of the courts or the way it's being perceived by the press, that they do have a dimension. And so instead of picking the ideal branch to assign it to, what we now think of modern separation of powers is thinking of the different branches as in dynamic tension with one another. And the question in the checks and balances spirit is, how do we tweak that balance to ensure that the flaws, all of them are to some extent politically accountable and politically responsive. All of them are to a lesser extent not politically responsive, and that's by design. So the question is, can we put the three branches in dynamic tension with one another in a way that one branch's oversight can compensate for the weaknesses of the other? Now, and this is very clear also in the importance of judicial review in the non-delegation doctrine and justifying it as a constitutional matter and other things. Is it all a reflection of this? Now, the funniest thing to me of all this is I've just actually restated the question and begged it entirely, because basically by saying we should be thinking of the branches as being in dynamic tension with each other doesn't actually answer the question of how we should tweak the non-delegation doctrine or Chevron. But in my mind, it's moving past the simplistic definition of, agencies are more politically accountable, which raises a whole bunch of other questions, and engage in the much more difficult question, which is, they are more politically accountable, but not perfectly so. But even in that world, we've always seen the need for judicial review in other institutions and trying to figure out the right way to tweak that. And I think that when you look at modern political science, we haven't gotten very far on that. And I hope that's an agenda that will improve in future years. Thank you very much.
Thank you very much. Boy, there was a lot there to chew on. After listening to you and Ilya before you, it makes me think we're probably going to have a part 2 to this program to get all of my comments and questions in. But thank you. And I want to go ahead and turn to Seth in a moment. But to all the attendees we have, feel free to put a question in the chat function, and hopefully we'll have an opportunity to get to a couple of those questions, which I'll moderate and choose among. So with that, Seth, go ahead, and if you'll just take maybe 5 or 6 minutes, Seth.
All right. Well, thank you, Randy, and congratulations, Ilya, on your terrific book. I'm going to try and get a signed book plate from you. And I think the history part right at the beginning is just fascinating. It's nice to see in about 4 or 5 chapters, a lot of the confirmation battles in history put in one place. I'd never seen that before, and I learned a lot from it. And so I really enjoyed the book. As someone who's a communications policy analyst, when it comes to the Supreme Court, I try not to get my hopes up too much, because as I went back to look at things, a lot of the cases that I would write about or analyze are a decade older or more. The Supreme Court has had a lot of interesting things to say very lately on administrative law, but getting into Communications Act itself, we have the 2013 decision in City of Arlington versus FCC. That was, of course, very important regarding wireless infrastructure. And there was some interesting preemption and Chevron related issues there. But a lot of the cases are a decade older or more. And what I'm not looking for is not so much the court to reinterpret anything in the Communications Act. It's just simply having, trying to perhaps break a logjam and where we've been in some of the policy stasis that we've seen. And the FCC, the Prometheus radio project case that was just argued the last week would be an example of this. Ilya mentioned that case earlier. That's been kicking around for about 17 years, involving 70s era media ownership regulation. Well, what I would like to see are simply occasions where the court could weigh in and acknowledge changed market conditions. And so it's not so much a matter of the agency, the court asserting its authority to interpret the law, but sort of looking to what the agency can do or can't do in light of those market conditions. The media marketplace, of course, is drastically different than in any time in the 70s or 80s. And yet we have sort of our seminal cases are based on pictures of the market and legal rationales that are tied to an outdated factual picture. So when it comes to broadcast regulation, for instance, a lot of the public interest sort of standard is tied to the idea that there is a significant spectrum scarcity. Not everybody can get on the air who wants to. Therefore, we need to give the FCC a lot more latitude in making its decisions. There's some other rationales that have come out from time to time about the invasiveness of broadcast media into homes and susceptibility of children to over-the-air TV. But those don't quite hold up because people, of course, consume media in lots of different ways rather than over-the-air TV. It's had a little bit of a resurgence lately, but it's a very different dynamic, and I think everyone obviously knows that. A similar situation exists in the cable video space, where a lot of the regulation that's arguably speech content based or very close to it regarding what cable and satellite providers need to carry on their networks, whether it's must carry regulation, least access regulation, program access, things that become what amount to forced speech kinds of restrictions. Those have been okayed going back to the mid-1990s and the Turner Broadcasting versus FCC decision in '94, where the court said, look, there are bottlenecks in the video distribution market that requires that these kind of regulations receive only intermediate scrutiny, whereas in other media formats, we would otherwise give them strict scrutiny. And so that's just kind of frozen in place. And the lower courts, when they've entertained decisions like this, for the most part, they've just acknowledged the old Supreme Court cases. They say, we can't really change this. This is the precedent that we have to apply. We had seen at the DC Circuit, then Judge Kavanaugh push back against that and acknowledge, look, we can't just simply rubber stamp what the FCC is doing in these cases, because the old bottlenecks, the old media monopolies or perceived monopolies simply aren't there anymore. We've got online video, we've got satellite, we've got all these alternatives. So simply just getting the cases out there on the docket to make a decision and sort of dealing with what the FCC can do in terms of its decision making and policy implementation in light of the changed circumstances and the pervasiveness of broadband internet services and wireless and all these different means that we have now to get into people's homes and give people access, mobile devices and all the rest, I think would be very, very significant. And it could lead to the end of just some of the back and forth situations like we see in the Prometheus decision.
Seth, thank you so much. So I want to ask a question or make a few comments, and then I'll give Ilya a chance to add anything he wants to add at that point. I'm going to actually pose a question to him and force him to give us a straight answer here. But in the meantime, if anyone wants to put a question in the chat function, feel free to do that. Okay, now Ilya mentioned a year 2001 law review article that I published. It was called "Is the Public Interest Standard Too Indeterminate to Be Constitutional?" or something like that. And of course, it dealt with this non-delegation doctrine, which we've referred to, which has to do, of course, with the extent to which Congress can delegate authority to the agencies, that is its lawmaking power. You know, the Constitution says in Article 1, Congress shall make the laws, and the executive, of course, executes the laws. But we all know that the agencies, including the FCC, do engage in lawmaking when they adopt rules after notice and comment rulemaking, and sometimes in other types of procedural processes. In 1928, in a case called J.W. Hampton, the Supreme Court basically, in dealing with a non-delegation challenge in that case, set forth this principle, which is still good law at this point, and which was adopted by the majority, I think, in the Gundy case. Ilya's going to correct me if I get off base here, but I think that's what the majority stuck with, the intelligible principle doctrine. Now, my point is this: the Communications Act has a public interest delegation in over 100 different provisions where Congress just tells the FCC to act in the public interest. Sometimes it's cojoined with other directions, but in the main, it's a public interest delegation. Now, in the first case upholding the FCC's authority under the public interest doctrine in that delegation, that was the NBC case. I think that was 1943, if I remember, in National Broadcasting Companies. And here's what Justice Frankfurter said in rejecting a non-delegation challenge to the public interest doctrine. He said the public interest is, quote, as concrete as the complicated factors for judgment in such a field of delegated authority permit. And basically that was it. The FCC, of course, continues to do a lot of what I would consider lawmaking under that doctrine. So here's what in Ilya's book, towards the end, he offers some suggestions to the court as to how we could take some of the politics out of court and detoxify, I think was the term that Ilya used, some of the controversy around the court. And so I want to pose this question, and this is on page 309 of the book. Ilya, you say the only way judicial confirmations will be detoxified, and the only way we reverse the trend whereby people increasingly see judges as Trump judges and Obama judges is for the Supreme Court to restore our constitutional order by returning and by forcing Congress to legislate on the remaining truly national issues, rather than delegating the legislative power to executive branch agencies. So you touched on this earlier, but do you believe that the court will actually do that with the current lineup? I know people believe we might be on the cusp of it, but give us your prediction specifically about somehow reinvigorating, if that's if that's the right word, the non-delegation doctrine or altering it?
Yeah, I think it's taken us decades to get to where we are. So there's not going to be an overnight shift. I don't have any easy or quick solutions. But as I said, at least 5 justices have indicated that they're opening to revisiting the doctrine, to perhaps invalidating a delegation in the right case. And if that case, I mean, it's much more likely for them to do that in a telecom case than in some culture war case where everyone's paying attention. It's going to be on the front pages. If they revive non-delegation in some minor way, whether that's with the public interest standard or something more technical, I think there's a real possibility to do that. And similarly with Chevron, I mean, the conventional wisdom going into the Kaiser case was that there'd be more appetite to overturn our deference, because that's just deference to the agency's own reinterpretation of its own, than Chevron, which is a much bigger deal. But the counterintuitive, and if you're thinking like John Roberts, case could be made that agencies should have less deference when they're interpreting Congress's work than when they're interpreting their own work. And so it could be that there's that, well, Roberts is no longer the 5th vote anyway, but I don't know about overturning Chevron altogether, but a cabining it much along the lines of what Kaiser did to our with, and this ties in Christopher's comment about science. One of Kagan's points in the majority opinion in Kaiser is to say that courts really only one of the factors of considering whether and how much to defer to agencies is the agency acting like an expert within its expert discretion or like a lawyer. In other words, yes, biologists or economists have skills and understandings and expertise that judges lack. But if it's the general counsel of the particular agency making a legal interpretation, well, courts can do that just as well as the agency's lawyer. And so that's going to be an important point going forward. But yes, on the non-delegation, I think it's ripe for reconsideration.
Well, on the Chevron deference point, just picking up on your last comment about that, as you know, the net neutrality decisions have bounced back and forth. And in each case, starting with Brand X, Chevron has been what I would call outcome determinative of the case, as the commission has swung between calling the internet access services, classifying them as either telecom on the one hand or unregulated information services on the other hand. So we've seen that back and forth now. So my question is, and I've raised this in a couple of pieces that I've written. Well, first of all, let's say, because this is almost obligatory now, it would be nice for Congress to actually legislate on this issue and pick up the ball and establish some type of broadband policy that hopefully I would think would be a sound one, but in any event, it would be appropriate for Congress to do that, I think. My question is, and Christopher can jump in here as well, knowing what we know about Chevron and knowing what we know about the history of the net neutrality proceedings, each time there's a switcheroo, and I think we're about to probably see another switch as the FCC gets reconstituted and the FCC goes back to regulating internet service providers as common carriers under Title II. Does that make it more likely that the court will decide to take a case and somehow say enough is enough and put that in some doctrinal framework that might alter Chevron? Would this be a good case because of that and because of the technocratic and economic issues that underlie the net neutrality debate? Do you think this may be a good case for that to occur? The narrowing of Chevron? Anybody?
I'm happy to offer my thoughts. I actually think that the Chevron, I don't think network neutrality is a good vehicle, if in the direct answer to your question. The fight is not over the words public interest. It's over things like offer and and a specific statute and understanding whether Section 706 authorizes things. And it's not these sort of broad delegations. It's more interpreting specific words, which are or are not in your point of view.
But I'm talking about Chevron, not non-delegation at this point, just
Okay.
the Chevron doctrine.
But in the Chevron doctrine, it's an interesting question because people regard telecom as something that's highly technocratic and that generalist judges aren't in a very good position to answer. So I think one of the core issues in the 2018 Restoring the Internet Freedom Order was interpreting economic evidence about the impact of network neutrality regulation on investment. And there were competing studies put in. I actually agree with the court's decision. I think as an academic, the one showing that there was a depressing effect on investment relied on what we call a difference in difference methodology, which is sort of state of the art. And I think they're much sounder, but that is a very technocratic assessment based on analytical techniques. And so the idea that you would then, if it's based on a decision like that, it's not a very inviting target for a judge to come and say, you know, this is the perfect example of why we shouldn't defer, because we judges are able to interpret that type of evidence better than agencies who have economists and engineers and other people on staff. I'm not very optimistic about that. What I do think could happen is what we've seen is not so much an attack on Chevron as sort of a reinterpretation of Chevron, which is along the lines Ilya pointed out, when does it apply? So for example, not sort of saying it doesn't exist, but putting gatekeeper issues on what's often called, under the words of Cass Sunstein, Chevron step 0. You know, it has to go through formal agency actions or before it gets deference, and it's not just a litigating position. And that falls in with Chenery doctrine, it falls in with the arbitrary and capricious review. And it's a very interesting sort of different ideas. And the other question is what makes something ambiguous? A big fight over Chevron is not just, do we include things other than text at step 1? So for example, if there's a competing canon like lenity, if it's a criminal statute, how do we take that into account? It's not about whether Congress has spoken to the issue, it's we have other interpretive devices we use that reflect other values. One last thought. I love, Ilya, your example of hour, and it brings out to me a great comparison of the two forces I was talking about. One is Niskanen, thinks ours is constructions of regulations, and particularly we're skeptical of agency constructions of their scope of their own jurisdiction. A political accountability theory would say, if that's a problem, the branches will pay it back, we should let them do that. The empire building theory of Niskanen says agencies will always construe their jurisdiction as broadly as possible, even though we know actually factually that sometimes isn't the case, but more often than not it is. And that should make us very skeptical of our. And sort of what you think of the animating philosophy behind these sorts of doctrines leads you to very different directions. And to me, a lot of that has to be unpacked as we work through whether Chevron deference should survive.
Ilya, there's a question put, which I think is one for you. Put aside the net neutrality proceeding. Are there current cases pending, and what are the cases that are pending that we might look for some change in the Chevron doctrine, if there are any this term?
Not this term. Not this term. There's more structural agency things, some more cleanup on the removal protections and other things like that, but we don't have a Foursquare Chevron challenge unless, you know, Prometheus ends up being somewhat about that.
Okay. Based on the oral argument, and I'm not sure you had a chance, although I suspect you did, on Prometheus, do you care to offer a prediction about the outcome of that case?
Haven't read the transcript, sorry.
Okay.
I have to say one thing. My very first major law review article was on media ownership, particularly in broadcasting, way back in the early 2000s.
Will you give us your prediction then?
Well, so the funniest thing is, nobody really cares anymore. You know, the funny thing, you know, it's a lot of policies based on the primacy of broadcasting as the unifying force of information, source of information. I just think factually that's untrue. To go back to something Seth said, we don't really have great tools to update this. And what we see in lower court cases, network neutrality and other things, once the Supreme Court has spoken, lower courts, even if they see different facts, are not supposed to update it. They're supposed to leave it to the Supreme Court to update it. So it's possible we will see that change here, but I really doubt it because, it's funny, what people don't really care anymore if a newspaper and a broadcasting station are owned by the same entity. And in fact, the economic evidence overwhelmingly suggests that that would be very, very good in terms of improving the quality of the content we get, particularly on local issues, which is what this is all about. So if there's a question, though just of relevance in an internet-based world in which people rely on broadcasting and newspapers less and less as their only source of information, it just seems quaint to me.
Well, you say people don't care, but I mean the people that are challenging the FCC's changes in the rules, proposed changes, they care because they continue to litigate the same issue over and over, even as it may become more evident to people like yourself that it really shouldn't matter or is the wrong. So there are people that do care, obviously.
Well, if you go back to what I wrote all those 2 decades ago, I actually think the FCC will win this one.
Well, I hope they do. Of course, that's my position, as a matter of policy in terms of sound communications policy. It's also, I think, and apparently this was not the direction the argument took, but when a reporter asked me about it before the case, I said that I hoped the court would focus on the text of the statute, section 202, as opposed to, the question of the record below and the arbitrary and capricious part, which I understand is an issue. And there was some supposed separation between the broadcaster challengers and the government's brief, which existed on that point. But to me, with the textualists that we presumably have on the court now, and when you look at section 202, this is the section of the Communications Act, for those in the audience, that requires the commission to review its media ownership rules every 4 years, and basically directs the commission to look at whether competition has altered the marketplace in a way that ought to compel them to change the ownership rules. I'm paraphrasing, and then it says in the public interest as well. It's another one of those cases where the public interest standard is included in the statute. But I think one literal reading of the statute would give considerable weight to the way that competition has affected the marketplace, and that textualists on the court could presumably, or maybe hopefully, look at that and say, that's the way that we're going to decide this case.
If I can flag one more thing that hasn't been mentioned yet, but could become a very lively topic with respect to Chevron deference, and that's section 230, right? Internet regulation and demands from both the left and the right to do things differently. Now, part of that is a legislative demand and different projects, by different people, but part of it is pressure on the FCC to do something. And that's not going to happen immediately because the FCC is now 2-2. And it won't be till later this year till Biden probably gets to confirm a fifth member. But there's certainly going to be pressure for the FCC to interpret its remit to change how section 230 is applied, or to start regulating in some way that is going to be challenged on that the agency doesn't have that authority yet.
But Randy, to go back to the point you raised, I'm actually not surprised at doing arbitrary capricious review as well as legal authority. They're parallel. First is there are separate questions under APA. One is it in the statute, and the second is, have you actually exercised your authority in a reasoned way? And to me, to say that they get to take competition into account begs a huge question, which is competition is not a self-defining term, and that in fact one of the biggest fights in economics is what is a sufficiently competitive environment to justify that sort of deregulation is going to be the kind of technocratic decision where we'll fall back on process review, not so much looking at the outcome, but did you consider all the relevant considerations? And I think that to go back to something Seth said earlier, it's ironic to me that in many ways, A court did a better job of this in the AT&T Time Warner decision, looking at how over-the-top video distribution is having a huge impact on cable, and at a time where they're losing, cord cutting is becoming an increasing phenomenon, that they continue to be subject to certain kinds of rules without having that being monitored is one of those classic technical reconsiderations which needs to happen. But in our current structure of Supreme Court not allowing lower courts to update earlier decisions, even when their factual underpinnings have gone away, really slows down some of the development of the law.
Yeah, no, I think that's a good point. Again, the interesting thing about the net neutrality controversy, though, is as much as you and I appreciate the technological and economic aspects that ought to be important considerations in making that decision, to some extent, that thus far every judicial review, has essentially, I believe, turned really on Chevron deference and following Brand X, and it's I don't know whether that's going to change anytime soon. Probably not soon in the courts, but maybe Congress will grapple with it. We're going to have to end this soon. We could go on all afternoon probably if I had my druthers, but we're not going to do that and impose on everyone. I just will quickly say I'm glad Ilya brought up 230. That's going to be going to be an important issue. Seth and I have filed comments with the Free State Foundation on behalf of the Free State Foundation and ourselves with the commission, and maybe that we'll at some point we'll do a program on that. I'll just say that our position in those comments, and it was contrary to a lot of others that often are on our quote side of the issue, the free market side. It's my view and Seth's view that the FCC does have authority to look at the statute and offer an interpretation of the statute. I won't go into all of the jurisprudence on it, but to offer an interpretation. Then it would be up to the courts to take that interpretation and do with it what they want under providing Chevron deference or whatever. I don't think the FCC can ultimately direct the platforms and the social media companies to take this or that action. But and the second point we made, because there's so much chatter in the other direction, I think, in the wrong, is that any revision that takes place of 230, whether by Congress or as a result of an FCC interpretation that a court follows, is not necessarily inconsistent with the First Amendment. There are just an awful lot of people that take the position that if you do anything to 230, that's violates the First Amendment rights of the platform companies. And I don't think that that's correct at all. But anyway, that's getting into probably another program. I want to thank Ilya especially for coming on. He's not as frequent a guest at our programs as Professor Yu, but hopefully we'll have an occasion to get you back, Ilya, and thank you.
I don't know. I've just exhausted all my knowledge of telecom law, so we'll have to find another topic next time.
Yeah, well, I'll send you a few more articles, and we'll keep educating you. But thank you very much. And again, I'll just say one more time, it's a really, really good read, and easy in the sense that it's written in a way that is very approachable, for lay people and not only Supreme Court scholars and lawyers. So I commend his book to you. Anything that Christopher Yu writes, I commend to you, and that's an awful lot of writing. Christopher, thanks for being back with us today. And Seth, as always, thank you. Your insights are always on point and valuable. So we appreciate that. So finally, I'm going to thank all of the attendees for joining us. We look forward to having you again at our next program, hopefully not too far into the future. And with that, I'm going to bid everyone goodbye. Have a great weekend. Stay safe, and we hope to see you again soon. Take care. Bye-bye, everybody.
See you later.